Murray.
Good morning. Roll call.
Good morning. Please stay here when your juror number is called. Juror 1. Here. Juror 2. Here. Juror 3. Here. Juror 4. Here. Juror 5.
Here.
Juror 6. Here. Juror 7. Here. Juror 8.
Here.
Juror 9.
Here.
Juror 10. Here. Juror 11.
Here.
Juror 12.
Here.
Juror 13.
Here.
Juror 14. Here.
Good morning again. And now you're going to hear the summations of counsel. Mr. Bright.
Thank you. Good morning, ladies and gentlemen. It hasn't been a very long trial, but in many ways it's been a particularly difficult trial. And that's because the nature of the charges themselves. But regardless of its length or difficulty, we've all seen how attentive you've been, and we want to thank you for that. We appreciate that. Now, we're just about done, but I'm going to call upon your patience just a little bit longer, because I need to review this evidence with you. I promise I won't take a moment longer than I need to, but this is a very important part of the trial. This is my last chance to speak with you. And there are a number of extremely important things that I need to say before you retire for your deliberations. First, I should mention that I'm at a bit of a disadvantage here. This is the last time I get to speak with you. Now, lawyers love to speak. There's no secret about that. But because the state has the burden of proving its case beyond a reasonable doubt, they get the last word. So, I am going to review the evidence with you, show you that the state has not met their burden of proof beyond a reasonable doubt. And I'm going to attempt to try to anticipate some of the arguments that the prosecutor will make when she gets up to give her closing statement. And I do that so that perhaps when you retire back for your deliberations, you'll say to yourself, what would Harley have said to those arguments? Now, in my opening statement, I mentioned how the prosecutor had set forth very serious charges against my client, and that she had presented the state's case in her opening statement in a very clear, intelligent, concise manner. And if that were all that you had heard, you would have been wondering, what are we even doing here? But we have these trials for a reason. And now you've seen we have these trials for a very good reason. And we know from our experience in life that things are not always what they appear to be at first glance. And I think it's fair to say that this trial has shown that to be true. Now, one thing I'm sure of is that the prosecutor is going to tell you that she is certain of what happened. And not only is she sure, but she's going to tell you that she's proven it to you beyond a reasonable doubt, and that Jeannie Mercado was telling the truth. But she hasn't done that. She hasn't even come close to doing that. No matter what you think of the prosecutor, and she is a very skilled, articulate, seasoned prosecutor. But despite that, it's just that the state has not met its high burden of proof. They have not provided you with the kind of reliable evidence that can establish with a certainty, beyond a reasonable doubt, that these accusations are true. In fact, if anything, the evidence demonstrates exactly the opposite. It demonstrates that no such assault ever took place. But ladies and gentlemen, we don't have to prove that. The defense doesn't have to prove a blessed thing. That's the state's problem. That's their burden to prove it all. And as I said to you in the opening, and as the judge will tell you in his jury charge, it's the prosecution's burden to meet that beyond a reasonable doubt standard. Ladies and gentlemen, let's turn to the evidence. Let me begin by saying that in cases like this, the job we have is extraordinarily difficult. I think it's fair to say that it's more difficult than in most cases because the charges are as serious as they come. And the evidence other than the conflicting versions of the two main witnesses, is sort of sparse. There's a paucity, a dearth, a lack of evidence in this case. And it's startling. But you saw it for yourself. In the end, we are left with a credibility question. But it's important to stress that it's not like many of the credibility questions we deal with every day in our lives. In a criminal trial, when we look at the witnesses, we assess their credibility in terms of the standard of proof provided by the law. What I mean is that when we make assessments about the credibility or the believability of someone in our everyday lives, we simply decide what or who we believe. For example, if two politicians are arguing about a point, we tend to believe one more than the other. But at the same time, we also recognize the reasonable possibility that we could be wrong. But a criminal trial is not quite the same. In a criminal trial, it's not enough to simply think one person is right or another person is wrong. To find someone guilty of a criminal charge, you must say not only that you believe the evidence presented by the state, but that you believe it to the exclusion of all reasonable doubt. There can be no doubt based in reason for any conclusion that a guilty verdict is justified. Ladies and gentlemen, is that even possible in this case? I submit to you that it's not. There's no way, based on what we've heard in this courtroom, to have that kind of belief that excludes all reasonable doubt. So let's look at the evidence. And we should begin with the forensic or physical evidence. Was there any, ladies and gentlemen? Was there any physical or tangible or forensic evidence that can help us in our search for the truth? Well, we know that on July 13th, 2014, several hours after the alleged incident, Ms. Mercado was examined by a nurse, Annette Casabona. And we know that after her examination, Nurse Casabona wrote a report setting forth her findings, and later she testified here in court. So what? Was her testimony of any value? Did it help us in our search for the truth? She did tell us that she observed abrasions that were consistent with anal penetration. But she could not say that they were the result of sexual activity on the night in question or sexual activity from the day before. She also could not say such abrasions were the result of consensual or non-consensual sexual activity. But none of this makes any difference anyway. It makes no difference because the defense does not deny that sexual activity took place. The question in this case is whether there was sexual activity between my client and Ms. Mercado. That's not the case. But whether or not that sexual activity was consensual. That is the question here. The existence of abrasions consistent with sexual activity is simply of no evidential value. It does absolutely nothing to help us better understand what happened. It does nothing to illuminate the truth. So what other physical evidence was there? Well, we heard about DNA results that did not conclusively identify my client. Was that important? Not in the least. Ladies and gentlemen, you'll hear the stipulation about the DNA. But even if the DNA did identify him, it would be meaningless again, because this is not a case about identification. It's a case about consent. And DNA evidence, like abrasions, is absolutely irrelevant to the question of whether or not Ms. Mercado consented to the sexual activity with my client. So, in the absence of any physical evidence that can help us, we have to look to the witnesses who testified. Let's begin by examining exactly what we know happened that night. We know that my client and his wife, Vicky, together with around 18 friends, went to a concert at Yankee Stadium to celebrate Vicky's birthday. We know they rented a party bus for their trip home. We know that Ms. Mercado did not go to the concert. Instead, she took that party bus from Clifton and met the rest of the friends at Yankee Stadium after the concert. Now, we know from there they drove the bus around for several hours, listening to music, drinking, and having a good time. We know they finally arrived at my client's home sometime between 4 and 4:30 in the morning. At that time, everyone went inside and they continued the celebration. We know, and this is important, we know there was no more drinking of alcohol once they left the party bus. Then, sometime after 4:30, they presented Vicky with the birthday cake that you saw in the video. And that video we'll talk about in a few minutes. Shortly afterwards, people began leaving. And by 6 a.m., the last people had gone, and the only ones remaining were my client, his wife Vicky, and Miss Mercado. At around that time, Miss Mercado decided she would sleep for a few hours at my client's house before leaving. She went to the couch in the guest room while my client and his wife went upstairs to their bedroom. As my client and his wife testified, they themselves had sexual relations upstairs. After that, Mr. Davila went downstairs to get a glass of water for himself and for Vicky. Now, at this point, there are very different versions of what took place. Miss Mercado claims that she was unconscious. She testified that she felt someone above her, but thought she was dreaming. She thought she was having a dream. In fact, she claims that she was not even aware. She wasn't aware she had sexual intercourse until she went into the bathroom and saw blood. Now, ladies and gentlemen, I'd like to ask you to think about that for just a moment. A man comes into the room where Miss Mercado is supposedly asleep on the couch. He performs anal intercourse with her. Anal intercourse. And she doesn't wake up. Just think about that. As disturbing an image as it is, I would ask you a single question. Does that sound believable? According to her, the episode took between 5 and 10 minutes. She tells us that even though she was supposedly in some kind of dream state, for 5 to 10 minutes. So how is any of this possible? How could somebody remain asleep throughout that kind of violent sexual assault? There might be one way it could happen. You may recall that I asked the nurse if there was any evidence of a date rape drug, because that is one scenario where it might be possible. If a person were intentionally drugged, then they might well remain unconscious throughout such an ordeal. But that's a scenario you don't even have to consider. Why not? Because you may recall that when I asked the nurse if she had tested for any kind of date rape drug, she told us she had. She did test. And there was none. There was no finding of any date rape drug. So it's not even part of this case. So then how is it possible for someone to sleep through such an assault? Ladies and gentlemen, your common sense tells you it's not. It's not possible for someone to simply sleep through a violent sexual assault with anal penetration. Nevertheless, the prosecution wants us to believe that it's possible because Miss Mercado was intoxicated. So, I ask you a question. How intoxicated would you have to be to have someone climb on top of you, penetrate your anus until you bleed? How drunk would you have to be? Dead drunk. You'd have to be passed out on that floor, unable to move, unable to know what's going on, not even awake, far from awake, close to dead to let that happen. I think we can all agree that if it were possible, a person would have to be absolutely dead drunk. The kind of dead drunk where someone is staggering, slurring, losing control of all faculties, and then passing out. So, ladies and gentlemen, let's ask ourselves, were there any signs of that kind of severe intoxication? You would certainly expect to see them in order to believe Ms. Mercado's version of the events. But that's not the evidence we have here. And that's not what the defendant or his wife, Vicky, had told us. Not even close. They both testified that Miss Mercado was not nearly that intoxicated. On top of which, there was no liquor once the party moved off the party bus and into the house. There was no liquor consumed after she left the party bus. So let's talk about the marijuana. Remember how she told you that she had some marijuana on the porch when they returned to the house? And what was so remarkable was that she claimed it was the first time she ever smoked marijuana. Ladies and gentlemen, come on. Is it a coincidence that all of this takes place and that night, without any explanation for the provocation of trying marijuana for the very first time in your life, she says, I smoked marijuana, but it was the very first time in my life. Is that believable? It's convenient. Oh, it's convenient for Miss Mercado to say, that was the very first time I ever smoked marijuana. It's convenient just as she's concocting this false accusation that entirely hinges on the degree of her intoxication. She's telling you that for the first time in her life, her entire life, she decided to smoke marijuana. Ladies and gentlemen, I submit to you that when she testified, it was obvious she was simply lying. Did she actually have marijuana that morning? Who knows? But it is more than obvious that if she did, it was not the first time she had ever smoked marijuana. She was simply lying. And it was obvious that she was lying. And more important than the lie about marijuana is the old saying in the law, false in one, false in all. Basically, it means that when a person is willing to lie about one thing, they're willing to lie about other things. It's an important way to assess someone's credibility, their believability, their trustworthiness. People make small lies to cover bigger lies. And in this case, her lying about it being the first time she ever smoked marijuana was designed very specifically and very intentionally to get you to believe that somehow she had an unusual reaction to the marijuana, a reaction that sedated her more than was actually true. But fortunately for us, we don't have to speculate about her condition that night. We actually have the hard evidence on tape. Ladies and gentlemen, do you remember when we showed you a videotape that was filmed sometime after 4:30 in the morning in question? That is the very best evidence of Miss Mercado's condition shortly before the alleged assault. On this tape, you saw Vicky Lopez holding her birthday cake. But more importantly, you saw Miss Mercado, who was wearing the black top and red pants, interacting with her. It's clear, it's perfectly clear from the video that Miss Mercado showed no signs whatsoever of severe or intense intoxication. In fact, the video shows just the opposite. Her walk was stable. Her movements were coordinated, and her demeanor was normal and appropriate for the occasion. So how does this person suddenly become so intoxicated that within a very short time she does not even realize that she was being sexually assaulted? Ladies and gentlemen, ask yourselves, did the woman on that tape appear to be so inebriated that a short time later she would be incapable of even recognizing that she was having a sexual encounter? And just as important, and however distasteful it may be to think about it, is it possible that someone in her condition would not even recognize that she was engaged in anal intercourse? Ladies and gentlemen, that is simply preposterous. It's not believable. There is absolutely no way the woman we see in that video would be unaware of the fact that she was being sexually assaulted in that manner. And that brings us back to another extremely important point in terms of the credibility of Miss Mercado's story. Bear in mind now that Miss Mercado and Vicky are best friends. When this takes place, Vicky was right upstairs, easily within hearing distance. If Miss Mercado was being assaulted by my client, why wouldn't she simply have yelled out for help? She would have known that Vicky was not only within earshot, but that she would have immediately responded. So why doesn't she struggle? There were no scratches or signs of struggle on either my client or Miss Mercado. Is it really possible that someone would be violently assaulted by their best friend's husband and remain completely silent and docile? Is that possible? Does that make sense, ladies and gentlemen? The only way to try to make sense of it is through the preposterous notion that somehow Miss Mercado miraculously transformed from the coherent person we see on the video to someone so utterly intoxicated, so dead drunk, that she did not even know that she was being violently sexually assaulted through the rectum. Is that believable, ladies and gentlemen? Does that seem consistent with common sense? You're allowed to use your common sense. You can use that in this court. The fact is, ladies and gentlemen, Miss Mercado is lying. Now, in saying that, it's not the defense's responsibility to show why she is lying. Yet I think it's important to dig a little deeper into her motivations so that we can make better sense of everything that transpired that night. So let's talk about motive for just a moment. Motive in a criminal case is something that is usually directed at the accused. We often hear about police searching for the motive of a crime. An easy way to think of motive is to ask yourself, why? Why did it happen? Why did the person do it? Typically, there are quite a number of different motives in a criminal case. Money, power, jealousy, and sexual gratification are the most common. But there are many other motives, and some that are more complicated than others. In this case, the question of motive involves the accuser rather than the accused. The prosecution will no doubt say to you, why would Miss Mercado make up such a story? Why would she just make it up? What would be her motivation for doing so? The answer to that critical question is complicated, but there is an answer. It involves what we've heard about her wanting to engage in sexual relations without her husband knowing it. We know from the testimony, that she lied to her husband when she told him she was at home rather than at the party. Again, we see small lies designed to cover a larger lie. Again, false in one, false in all. She lied to her husband about where she was. We also know Miss Mercado spoke with Vicky, who was her closest and longest friend, about the subject of cheating on her husband. We know she told Vicky that the way to keep her husband from learning about her cheating was to have anal rather than vaginal sex. We also know that on the night in question, while her husband thought she was at home, she was actually on a party bus riding around New York City, sexually flirting and giving lap dances to the people on the bus. Ladies and gentlemen, I don't think it takes any special insight to see that she had something on her mind that night. But that's not to say that the encounter was planned in advance. Much of the time, these situations arise spontaneously. They arise without any planning, and that's what happened here. Had Roger not come down for that glass of water, we probably would not be here today. But the fact is he did. And by doing so, he created an opportunity for Miss Mercado to put into action what she had clearly been thinking about for some time. And so, when she saw Roger on the first floor, she invited him to engage with her in sex, specifically anal sex. And Roger agreed. Now, let me be perfectly clear. No one is here to defend the fact that my client was cheating on his wife, who was right upstairs. It was a terrible and reprehensible thing for him to do, but it was not a crime. Much less was it any of the enormously serious crimes charged by the prosecution. He did not force himself on Miss Mercado, as she claims. He was invited to have sex with her, and he did. But however reprehensible and egregious it was not forcible rape. What it was an infidelity to his wife. A wife, ladies and gentlemen, who has found a way to forgive him and stand by him here in court. I submit, ladies and gentlemen, she would not have found the path to forgiveness if she had even the slightest doubt that he might have raped her best friend. And remember that all of the people in the world, Vicky is the one who knows both Roger and Jeannie the best. Her assessment is more important than anyone's, and her steadfast defense of her husband, notwithstanding his inexcusable transgression, speaks volumes. But moving back to motive, there was something that Jeannie, in her plan to cheat on her husband, did not anticipate. For some reason, she believed that having anal sex would produce no evidence of having had sexual activity. Thus, in her mind, her husband would be unaware of her cheating. But something happened. Something occurred that she didn't foresee. And that was the bleeding. When she saw blood, it caused her to panic. That would not be easy to explain to her husband. It would also not be easy to hide from her husband, especially if she bled again. And so, in her panic, she called her friend, Leslie Lopez, and her aunt, Alma Perez, and told them that she had been raped. Once she called them, there was no turning back. She probably didn't anticipate that things would get this far in the legal system. But her husband was a police officer, and in her way of thinking, there was no way for her to go back on her initial claim. At the same time, it's interesting to look carefully at the testimony of the two witnesses with whom Miss Mercado spoke early that morning. Beginning with Leslie Lopez, it's interesting to see that Leslie, the person Miss Mercado called, clearly had her own doubts. She gave a statement to the police in which she said, and I'm quoting exactly, quote, "If I'm being 100% honest, I don't see Roger doing something like that," closed quote. Ladies and gentlemen, this is coming from the very lady who brought Miss Mercado to the hospital. Obviously, she had doubts about the credibility of Miss Mercado's story. It is also interesting to look at the testimony of the other witness contacted by Miss Mercado, her aunt, Alma Perez. What struck me was that Alma had to tell Jeannie to get out of the house. Why on earth would a person who had just been anally raped even think about staying in the house? Why wouldn't she get up and run out of that house herself? Wouldn't the first instinct be to get the heck out of there as fast as you could? Yet it was only after speaking to her aunt that she actually left the house and went into the car. Now, there's no doubt that Miss Mercado was upset at this time. Both Leslie Lopez and Alma Perez testified to that. But the question is, what was she upset about? The prosecution will tell you that she was upset because she was raped. But that's not what the evidence tells us. On the contrary, she was upset because she was going to have to face her husband, a police officer. And the only way to do that would be to concoct a fictional story about being raped. And even with that, she was not all that sure that he would believe her. In fact, you heard Leslie Lopez herself testify. that Miss Mercado herself was very concerned about what her husband would think, and specifically that he may blame her. Miss Mercado told the police, and I'm quoting Miss Mercado, quote, "What's my husband going to say? How am I going to tell my husband? What's he going to think?" Close quote. And so, while it does seem clear that Miss Mercado was upset when she reached out to Leslie Lopez and her aunt, it's far from clear exactly what she was upset about. In fact, the evidence strongly suggests that she was upset because her plan to have anal intercourse backfired when she saw the bleeding and believed it would be extremely difficult now to keep this from her husband. She expressed those sentiments to Leslie Lopez, and it's consistent with the plan described to Vicky about using anal intercourse in order to hide the fact of having an extramarital sexual relation. The prosecution, of course, will reject all of this. They'll say this is nonsense. They will reject the evidence that shows Miss Mercado was the instigator of the sexual encounter. They will replace the evidence with speculation. They will speculate that Miss Mercado's emotional state has only one explanation, and they will give no credence whatsoever to any other interpretation. But there's a tremendous danger to that, ladies and gentlemen. There's a tremendous danger in speculating about what happened in a criminal case when you don't have the evidence. That's why, ladies and gentlemen, every lawful verdict must be based on facts and not on speculation. There's no principle in law more important than that one. And when I say speculation, what do I mean? Well, if you look up the word in the dictionary, you'll find things like speculation is based on conjecture or surmise. We don't do that in a criminal trial. Yet sometimes in the absence of facts, it's easy to imagine something happening, or it's tempting to think it could have happened a certain way, or might have happened in a certain way. But that kind of thinking is nothing more than speculation, and we should never, ever indulge it or let it take place of hard, cold facts. But in this case, because the factual evidence is so weak, the prosecution's case has been built entirely on the credibility of a single witness who we know has a motive to lie. What other evidence does the state have against Mr. Davila? Ladies and gentlemen, no doubt the prosecution will say that the simple fact that Ms. Mercado was upset constitutes additional evidence. But we've shown why she was upset. Moreover, that hardly reaches the kind of evidence required to find a person guilty to the exclusion of all reasonable doubt. And that's it, ladies and gentlemen. That's the sum of the government's case. They have no more evidence against my client. So how can a case be built against him? There's only one way, and that is to engage in speculation, to replace hard facts with imaginings, to draw spurious connections and invent evidence that doesn't exist. The state has resorted to this kind of speculation throughout this case because there are no facts, no hard facts, no reliable or trustworthy facts, no forensic evidence, no corroborating witness, nothing at all that proves beyond a reasonable doubt that Roger Davila committed a crime. This case that looked so strong when the prosecutor gave her opening statement has been exposed for what it really is. A case that is built on nothing but the word of a single witness who has been completely discredited. And that brings us to the next topic. Ladies and gentlemen, when you're back in that jury room deliberating, I would like you to ask yourselves a simple question. What other decision in life would you make? What other decision in life would you make that you would feel confident in based upon the degree of trustworthiness of the testimony we've heard from these witnesses? Would you make any decision at all based on this kind of testimony? Would you buy a used car based on the trustworthiness of this evidence? Would you put a mortgage down on a house based on the trustworthiness of this kind of testimony? I submit to you, ladies and gentlemen, that you would not make any important decision whatsoever based on the kind of evidence we've heard in this court. How could you? How could you? What kind of evidence could anybody have in the veracity, the truthfulness of what you've been told? And yet the prosecution wants you to make the most important decision imaginable, a truly momentous decision, one that affects the life and freedom of my client. They want you to make a decision to find him guilty of one of the most terrible crimes, and to make that decision based upon the deceptive and untrustworthy evidence that's been presented. You should not allow that to happen. You should preclude that from happening. There's too much at stake. My client's life is on the line. The prosecution would be asking you to believe in a case that their own witness, Leslie Lopez, was skeptical about right from the start. Remember what she said, quote, "If I'm being 100% honest, I don't see Roger doing something like that," close quote. She didn't believe it, and the evidence doesn't support it, and you shouldn't accept it. Let's talk a moment longer about the burden of proof, because it's absolutely so critical in a criminal case. It may be the single most important legal principle in any criminal trial. The judge will tell you, don't take my word for it, the judge will tell you that the state has the burden of proving its case beyond a reasonable doubt. Ladies and gentlemen, you've heard me argue strenuously, emphatically, in the fact that Ms. Mercado cannot be trusted. You had a chance to listen to her and evaluate her the same you would anyone else in life. And I would submit to you it is clear that her testimony was, at the very least, absolutely unreliable. But let's, just for argument's sake, let's ask ourselves, not whether she lied to the police, but only whether it's reasonably possible that she lied. Let's just ask ourselves, is it reasonably possible that she lied? Is it a reasonable possibility that she lied? If we answer honestly, it may seem absurdly obvious, yes, of course, it's reasonably possible that she lied. Now remember, I'm not asking you whether you're certain she lied. I'm not asking you if you're firmly convinced of it. I'm not even asking if you think she probably was lying. I'm only asking if you believe that there's a reasonable possibility she was lying. That, ladies and gentlemen, is the single most important question in this case. And I would ask you, ladies and gentlemen, when you go back into that jury room to ask yourselves, is there a reasonable possibility that she lied? When you do think about her reasons for telling the story she did, think about the implausibility, the unbelievability of her story. Think about the contradiction between what you saw on that videotape and what she claims. And then, ladies and gentlemen, ask yourselves again if there's a reasonable possibility she was lying. That's such a critical question, because if the answer to that question is yes, if it is reasonably possible that she was lying, then that, ladies and gentlemen, is reasonable doubt. That alone, the existence of a reasonable possibility that she was lying, that the story told to you by Ms. Mercado was untrue, that means that the state has not met its burden of proof beyond a reasonable doubt, and the verdict must be not guilty. Ladies and gentlemen, there's a very good reason for that high burden of proof. We here have a terrible accusation, the rape of a woman. There's just about nothing worse than that. On that point, no one here disagrees. And no one should ever attempt to diminish the pain and suffering felt by those who are true victims of such assaults. But we must follow the evidence. And the evidence fails to show that my client committed a crime. As I said to you in my opening statement, we are not here to decide whether or not such a sexual assault is terrible and tragic. We know that it is. But we are here for a very different purpose. We're here to answer a far more narrow question. Did my client rape that woman? The state has brought these charges against him, and now they must prove them. In any free society, the burden of proof must always be on the one making the accusation, beyond a reasonable doubt. That is the standard for any jury in any criminal case in America. You, ladies and gentlemen, you alone decide if there is a reasonable doubt. You must search for reasonable doubt, which is, as I've said, could mean a reasonable possibility that Ms. Mercado was not being truthful. If you find that to be the case, that alone, a reasonable possibility that she was being untruthful. If you find that alone is your reasonable doubt, and that requires a verdict of not guilty. Ladies and gentlemen, we selected you because we had a sense about you, a belief that you would follow the law and carefully evaluate all of the evidence. And that's what I ask of you. Review all of the evidence. Listen to each other. Hold these proofs up to the light of common sense. Ask yourselves, is this the kind of evidence I can rely upon? Is this the kind of evidence I can trust in order to convict a man, an innocent man, of one of the most serious charges imaginable? When you're done with that review, ladies and gentlemen, when you've held this weak evidence up to the light of common sense, I feel sure you will come back in here and give a true verdict. One in which you say simply that the state did not meet its burden. It did not meet its burden of proving my client guilty beyond reasonable doubt. They didn't prove it. And the truth is, they didn't come close to proving it. And I'm confident that the one thing that you will find, absolutely in this case, is that there is a reasonable possibility that Ms. Mercado lied. And then you will come back with a truthful verdict of not guilty. Thank you.
Thank you, Mr. Breite. Sir?
Your Honor, we have 10 minutes just to set up, move the podium, and
All right,
any
welcome to the
review.
jury.
Thank you, Your Honor.